Got to do that for several weeks. Feels good. Good afternoon, everyone. House tax will please come to order. Make sure I remember to mute my computer here. First item of business would be bill introductions. Do we have any requests for bill introductions? Chair recognizes Representative Corbett.
Thank you. It's 21 RS 1658. Basically, governmental entities commanding usage of property during like the shutdown. So that's where you're at.
Okay, committee questions? Representative Clayton.
Thank you, Mr. Chair. Could you clarify just a little bit, Representative? Also, I'm kind of hard of hearing, so thank you.
An act concerning the Kansas Emergency Management Act relating to an award of compensation requiring payment of general government entities, commandeering or using property, amending KSA 48933, and repealing the existing section.
Thank you very much.
Committee, any further questions? Seeing none, any objections to the request? Seeing none, the request is approved. Do we have any other requests? Chair recognizes Representative Estes.
Thank you, Mr. Chair. I have two bills to introduce. The first one is 21 RS 1112, an act concerning taxation relating to motor vehicles, allowing disabled veterans to receive a sales tax exemption for up to 2 motor vehicles. Would you like to handle them separately, or would you like me to continue?
Yes, we will take them separately, and pardon my memory here, but we actually passed a bill that was similar to that. Do you know if there's any difference between that? Does anybody remember what bill number that was? 2313?
From what I was told by legislative research, there was something done for active members, but not for totally disabled veterans. And if I'm incorrect, I'll be happy to celebrate that it's already done.
That's good. We will address that request. Committee, are there any questions? Any objection? If not, RS 1112 is approved for request, and you continue with your second one.
Thank you, Mr. Chairman. The next bill is 21 RS 1110, an act concerning income taxation relating to credits, creating a refundable family caregivers of disabled veterans tax credit.
Thank you. Committee, any questions? Any objections? Seeing none, the request is approved. Thank you.
Thank you very much.
Any further requests for bill introductions? If not, I have one. I would like to request it for introduction, 21 RS 1711. It is a standalone bill on property tax exemption for health clubs. Are there any questions? Representative Baker.
Thank you, Mr. Chairman. I didn't quite catch that. Could you repeat that?
You need to exercise your ears a little bit. Huh? Any objection? Seeing none, the request is approved. We will move on to our first item of business for today's meeting, and that is an overview of a recent court ruling for the revisor. Let me pull that up. The bill that we are scheduled to work today is House Bill 2316, and there was a recent district court summary judgment that I wanted to have the revisor brief us on as a committee before we worked that bill. So at this time, I would turn it over to the revisor.
Thank you, Mr. Chairman. Yes, as you stated, there was recently a court case, federal district court case in Kansas, dealing with the statute KSA 16A-2-403, which is brought into play in House Bill 2316, which I believe will be worked later today. I'm just going through briefly the opinion that was issued my knowledge of this case derives solely from this opinion, so I have no additional background information on the case besides what is in the opinion. I mean, it is a 23-page opinion, so there's quite a bit of information, but that's where my sole genesis of my information derives from. Secondly, well, I'll just go through that quickly. Essentially, what is going on in this case is the plaintiff, which is Cardex LLC, it's an out-of-state company. It sued the state of Kansas. However, they sued the attorney general as the named plaintiff, but essentially they're suing the state. He's just as the official capacity as the plaintiff. Essentially, what the suit alleges is that the statute is unconstitutional restriction on commercial speech in violation of their First Amendment rights is the main allegation in this lawsuit. And basically what this company does, according to this opinion, is that this is a technology company that supplies software to merchants to display prices, which would include the surcharges on purchases made by a credit card. So essentially they're a supplier of software to vendors. And so that's why they're suing the state of Kansas, and then alleging that their current prohibition of surcharges is an unconstitutional violation of commercial free speech. And that is the issue raised before the court, is whether or not the statute violates essentially the U.S. Constitution, as it would prohibit the plaintiff in this case to communicate price differentials in a manner displayed on the plaintiff's products. The case status is currently, as the chairman stated, is being heard in the District Court of Kansas, Federal District Court. They're at summary judgment stage, so the case is still ongoing. The judge in the case issued an order, especially it's a little complicated, but in the fact they issued a declaratory judgment that the statute as applied to the plaintiff would violate the plaintiff's rights under the First Amendment. However, the court did decline to issue any sort of further injunctive relief prohibiting, any application of the statute. So I would say at this point, it kind of gives an indication of where the court may be going, but not necessarily 100%, where essentially the state can't take any action against the plaintiff in this case for violation of its products under this statute. And that's really where things stand at this point. This opinion was issued less than a month ago, so I did check this morning and there were no further court filings to date, but it's only been less than a month, so that's not any sort of, I would actually be surprised if there had been anything else filed. And so this issue under this statute is being litigated for the fact that, there's a question, or at least an allegation that would be unconstitutional as applied to certain plaintiffs. And that's kind of where things stand at this moment. With that, Mr. Chairman, I'd be happy to stand for any questions.
Thank you, Mr. Siebers. Committee, any questions? Representative Kelly.
Adam, could you put that a little more in layman's language for me?
Sure, I'd be happy to. Are you referring to the declaratory judgment portion, or just everything in general?
Yeah, can you condense it down to just a couple sentences on what this does, and where it puts us in relation to what we're going to consider today?
Yeah, I can give it an effort. Essentially, the judges. It is a little difficult because the judge didn't go forward and say that the statute itself is unconstitutional. Because that would pretty much require an injunction for any application of the statute going forward, and the judge declined to do that. So all the judge did is say that as applied to this plaintiff, the statute can't be applied to them. So it's not exactly a real clear cut of what's going to happen or what could happen. It's a very narrowly tailored relief that was issued to this plaintiff at this point. Going forward, they still have to litigate the true impact of whether or not decide whether or not this statute is unconstitutional on its face or its application. So none of that's been decided yet. So it's still up in the air as to, is the statute unconstitutional? Is there sort of, violation, anything like that? So that's undecided. I can't answer anything beyond the fact that the court may be giving some signals that there are some concerns that they have by issuing the fact that they found issue with the declaratory judgment. But unfortunately, at the initial stage, there's still summary judgment proceedings, and it was such a partial summary judgment issuance. I can't really go much further into the fact that of what the court will do going further.
Representative
I hope I did.
Blex? Done, okay. Any further questions, committee? I realize that this court case doesn't specifically address the bill that we're taking a look at, but one of the interesting things about this summary judgment is that it doesn't necessarily declare the entire statute unconstitutional, but yet they have found that there are some inconsistencies, which is why we're still going to take a look at this bill 2316. Any further questions? Seeing none, Mr. Siebers, thank you for that overview. And at this time, committee, we will take up House Bill 2316, and I'd once again turn to Mr. Siebers to give us a brief overview on the bill.
Thank you, Mr. Chairman. As kind of talked about earlier, House Bill 2316 would repeal KSA 16A-2-403. And what that is, it's the statute dealing with the financial transactions that prohibit sellers from imposing a surcharge when a credit or debit card is used to make a purchase. And by repealing the statute, it would allow for the imposition of a surcharge by sellers. So that's really, and that section is really found in the repealer part of the bill. It's not the language itself. Since we're repealing the statute, it won't be in the language of the bill. The bill itself, the main language you see, essentially clarifies references to the statute that's being repealed to kind of clean up, since they would no longer would apply. And with that, I'd be happy to stand for any questions.
Any questions for the reviser? Seeing none, thank you for that overview, Adam. And I would turn to the committee at this point and ask, what are your wishes for House Bill 2316? Chair recognizes Representative Mason.
Thank you, Mr. Chairman. I move that the committee find House Bill 2316 favorable for passage.
Second by Representative Corbett. Any discussion? Representative Turner.
Thank you, Mr. Chairman. As I was looking through testimony on this bill and remembering the hearing, one of those giving testimony suggested that it be amended to say that merchants cannot charge more than the actual cost of credit card process, or 3.5%, whichever is lower. And I think as the court case that was just reviewed by the reviser, I believe it mentioned 4%, basically saying that merchants shouldn't profit off of this surcharge. So it should be reflective of their actual cost base and not just be up to their discretion to charge 10%. And so, I don't have a formal amendment to introduce, but I just wonder what committee thought is in terms of putting some structure around it rather than just an open-ended passage.
Right, and I appreciate that. And I may turn to, I think that was Mr. Tom Pallas that had that in his testimony. And I'd recognize Representative Corbett, and then I might invite Mr. Pallas to come up to the podium and visit about that. Chair recognizes Representative Corbett.
Thank you, Chairman. Maybe some insight to the question he was asking, that the dilemma that with this situation is every company signs a contract with a credit card provider, and there's really no set percentage or transaction fee or if you take these credit cards and you get your statement every month, you'll have fees that maybe 6 or 8 inches long of just various fees and fees and fees that the credit card companies charge the vendor. So it's hard to put I think it'd be hard to put that into a box or whatever, because all the credit cards vary and all the businesses vary. So maybe if this does get passed, maybe the industry may clean up its act a little bit. I don't know.
Mr. Pallas, would you care to address the committee on that?
Thank you, Mr. Chairman, and I appreciate that someone read the testimony. It was good. However, in light of the lawsuit, to keep the bill clean, perhaps we just pass on the fees that we don't have a set amount. You go ahead and pass on the actual fees that you've been charged by your processor. That's how I would take it from here going forward. Just trying to keep it as clean as possible to where there's not any ambiguity within the percentages.
Right, and one of the things I'm curious about, if you have to display or inform your customers on such a notice or a disclosure, where that fee could be different depending on what card I pull out of my wallet, it seems like it might have the potential to complicate the process, because as a retailer, you don't know what card I might have.
They vary. All the cards do vary, as you well know, to some extent. And putting a disclosure, as you're talking about, either at the point of sale or what have you, I think the only thing you could put in there is that credit card fees are being assessed to the consumer, or something to that effect. You're going to see it on the receipt when the total sale is done. You'll see that amount on the receipt. As far as disclosure, we'd have to come up with probably some language, I guess, that would say something to the fact that this sale will, if you use a credit card, this sale will incur credit card fees. Because like the state now says 3%. And whether or not, whatever card you're using at that point in time, it's 3%. And that's when I put into my testimony, I thought that would be a good number, but at the same time, the disclosure is important to the consumer. I don't disagree with that.
Representative Blex?
Thank you, Mr. Chair. And I don't know, you may want to stay right there. Would this surcharge be subject to sales tax? Are we going to have a tax on a tax? Can you tell me that?
Well, Mr. Chairman, right now, your sales tax is taxed, or you do have credit card fees on your sales tax today. And I think we tried to pass a bill several years ago that would remove the credit card fees off the sales tax, and that didn't go anywhere. But at this point in time, sales tax is included in the fees.
Thank you.
And I did confirm that with Department of Revenue this morning. I visited with Kathleen Smith just to verify that, because we'd heard that question when we had the hearing, and it was answered, but just wanted to have some good assurance on that. But yes, the gross receipt it includes that surcharge, and then sales tax is applied to the gross receipt. Representative Kelly?
Thank you, Mr. Chair. So, Tom, with the fee charge, you said the 3%. Was that in there that was the maximum? Or just 3% would be charged?
That's what the state state. The state of Kansas, or local government, they charge 3%. I think what I put in my testimony was 3.5%, because it could go as high as 4% in many cases. But
so could I, if I went in and it says credit card charge is going to be applied, could I take the 3 cards out of my wallet and see what the best price was?
I don't know the consumer knows it, and I don't even know if the retailer knows it. Well, somebody from the retail is going to know it, don't get me wrong. They do know that.
But I mean, there's not an easy way to have an option that if I have a card that has a 1% fee or a 2% fee, that I'd know on this transaction that this would be the best card to use?
I doubt that the consumer would know that.
Okay.
Representative Baker?
Thank you, Mr. Chairman. So, two questions. So, are we trying to incent everybody to go back to cash? Is that the idea? We're going to give them a cash discount?
No, we just want to be like the state of Kansas. That's what we want to be like, is that we want to be able to have that option, if we so desire, to pass on our fees to the consumer.
So, coming out of the retail industry, the amount of that fee is different for each retailer. Because your gigantic multi-country retailer that you work for charges like 0.1%. That's his fee. Whereas Joe Blow down the street that has his little liquor store that sells $100 a day, he pays 3.5%. So once again, it's kind of a discrimination, and it would incent people to go more towards the large multinational retailers. Is that correct?
I don't know if that's correct. I just think that the consumer, if you look at today, credit card usage in our stores is 85% today. And the younger generation, that's all they know is a credit card. Mr. Chairman, I'm sorry. That's all they know is they use a credit card. They don't use cash. If they're smart and they don't have those fees, you pay cash.
So, follow up on that. So I'm one of the old guys that puts cash in my billfold, and when the cash is gone, I go home. But by going to the credit cards and stuff, the number of liquor store robberies has gone down immensely because you don't have any cash in there, which is kind of what most people are after when they come to that deal is cash. And it's also a lot easier for the economy to be tracked when you use those credit cards. Mm-hmm. I just have a real problem with those fees not being the same for all retailers. And when you come in and you're incenting those large retailers that have those sweetheart deals, you know, they have, some of them even have their own card, mm-hmm. you know, and they make a lot of money off that card. You know, I remember some of the retailers in the past made more on their credit cards than they did off their operations. So anyhow, I just, a little heartburn on that. Thank you, Mr. Chairman.
I would remind the committee, we're working the bill. Let's keep our questions pertinent to kind of based around what Representative Turner was talking about. If we want to try to request an amendment to have some clarity within this bill, if we want to try to do that today or not. Chair recognizes Representative Corbett.
Thank you, Mr. Chairman. I think the biggest problem we have here is you've got too many credit cards, too many companies, too many moving parts. The point of this bill is just as simple as this. Whatever it swipes, it gives the business owner a chance to pass it on. And I guarantee you after a while, if this catches on, you will sooner or later know which card of yours you'd like to use. And we didn't seem to have much of a problem doing this for schools or anybody else that's asked for this. This is just giving business a chance, and they don't have to charge it. Just pass it on. And you're never going to get a level playing field because there's just too many credit cards, too many contracts, too many whatevers. But that's my suggestion, is just pass it out clean and let it work itself.
Mr. Palace, thank you very much for your attention. Is there any further discussion? Representative Sanders.
Thank you, Mr. Chairman. I just want to make sure that I'm understanding this, because as I was reading through this this summary, it seemed to me one of the questions was a matter of free speech, and what this CardX company does, as I understand, is it shows the consumer what's being charged when they use a credit card. Is that not correct?
I apologize. I was trying to check the people online. What was your question again?
So as I read through this summary, I thought at least part of the issue was an issue of free speech, and that this CardX company shows what the charge for using the credit card is. Is that not correct?
I believe so. Mr. Siebers, do you want to comment on that question?
Sure, Mr. Chairman. Yes, I believe that is correct. That's why the ultimate resolution, a declaratory judgment, may be a toothless tiger in this case, where I'm not sure what that actually gets at this point until the litigation plays itself out. It's the company itself, I believe, does just sell the programming to the vendors or to the retailers to then use. So I would think they would be the ones who would be probably more liable for violating the statute, the underlying statute. However, there is some reference that they could somehow be deemed an agent and could be possibly liable in some fashion. But I think the point they're trying to make in the underlying and the lawsuit is to have the statute brought into the constitutional question. So even though they've gotten a partial win at this point, it's probably not the ultimate resolution they're looking for.
So if what this company wants to do is show the amount of the credit card charge, again, as I understand it, I could be dead wrong about this, is it currently illegal in Kansas to charge one cash price and then charge another credit card price?
Essentially, there's a little gray area, but retailers can't if they have a listed price of $10, you can't go up with a credit card and then they charge you $10.40 is essentially. So that's why their software has very little impact, I would say, at this point, just because no one can use it, would be my guess. Because they can't, whatever the stated price on the item you're going to buy, you can't then levy an additional charge. It gets a little gray where you can go up and they can offer you a cash discount, which is different, but you can't increase the price with a surcharge.
But I see all the time where there are retailers who sell gasoline will advertise a cash price and a credit card price. Is that legal?
There is an AG opinion that does state that you can offer a cash discount. Getting into all the technicalities of what is a discount versus what is a surcharge, it gets a little gray, I'm not gonna lie.
So last question, so if we were to support this bill, what would it change? What would it do?
Essentially, by removing this statute that exists currently, if someone would go up to make a purchase with a credit card or a debit card, conceivably, the retailer could levy an additional charge for use of that credit card or debit card when paying for an item. So they could state a price of $10. You go up there and you use your credit card, they could levy an additional charge of, it was 3%, that you could levy that additional 3%, because right now it's currently prohibited from doing so.
Thank you, Mr. Chairman.
If I could help simplify this, and I'll probably confuse myself more than anything, but the fuel price is kind of a different item. If you can imagine yourself going into your local grocery store, and similar to what you see on the gas pump, on the little tag on the shelf, it has one price, then it has a cash price on there that's less, that discount. You don't see that. Technically, with this bill, they can list that one retail price, and then they can apply the surcharge at the register depending on how you choose to pay. If you're paying cash, it's the price that's on the label. And if you're paying with a credit card or any type of credit account, then they would, with the passage of this, or repealing this, what's currently on the books now, that retailer would then be allowed to add that surcharge onto the final bill, but they would not have to advertise that in the price, similar to what the gas pumps do. Thoroughly confused everybody, including myself. So, Representative Wassinger.
Thank you, Mr. Chair. I know for a fact that American Express charges more for their to use their credit card. And I've asked local merchants, would you prefer that I did not use that? Because I get the best points on that. And most of the merchants that I've talked to said, no, that's what we do. We try to get the points and we try to get the miles. So I think it's important that we educate consumers about the price of surcharges, but I don't think we should stop retailers from wanting to recoup that surcharge. And I think it's important that if we do that, they can only recoup what their surcharge is. And I like the transparency and people knowing what they're paying for. So thank you.
Representative Day.
Thank you, Mr. Chairman. I had written down a couple of questions when we went on this hearing, and they were just, I think they kind of follow up on this. I was wondering, why is there a prohibition on this on the books in the first place? And why are we one of only 4 states that have it in place? 4, right? Is that correct? We know.
That's what was provided in testimony, yes.
Right.
I think it's Kansas, Colorado, Maine, Oklahoma, maybe.
So the prohibition is in place for, does anybody know why it was put in the books in the first place? Sorry.
Mr. Sievers, do you have any history on the statute when it was created?
I can pull up the year, but I don't have any other background information on the statute, unfortunately.
And I apologize for not having done that research myself and reaching out to them, but I just remember writing it down and wondering. I appreciate you indulging my question. Thank you.
I would assume maybe it was to discourage the use of credit and paying your bills, perhaps. I'm not sure. I'd like to recognize Representative Stogstill.
Thank you, Mr. Chair. Maybe somebody could just kind of clear this up for me. I've done some research on this over the last week. Found out some, I think, rather interesting things. One, appears the profits made by the credit card companies over the last year was somewhere in the neighborhood of $90 billion. And I'm just wondering if we pass this bill and retailers can pass on that credit card charge onto consumers. Right now, they negotiate with these credit card companies, like one of the previous representatives was talking about. It could be very small, or it could be up to as much as 4%. If we pass this that says that retailers can pass this charge on to consumers, what's to keep these credit card companies from going to these retailers and saying, you know, we're gonna negotiate. We're actually, from what I understand, it's more of a take it or leave it type situation with some negotiating in there. But what's to keep them from going to those retailers and saying, you know, we're gonna up all of our charges to 4%, and you shouldn't complain about this because it won't cost you any money. You'll just send it on to your consumers, and that bothers me quite a bit. Is there something that would prevent them from doing that?
I would say free market competition. If they're going to raise their rates and the consumer or the retailers pass that on, I mean, that's just my own personal speculation. I almost see this as creating a competitive advantage to where maybe they'll start lowering some of those rates. If they increase the rate and they start losing the business because people don't want to use that, I'm not going to use a name, but if they don't want to use their blue card or their black card because they know it's going to charge more on the rate. That's just my personal.
Okay. Well, that, as I say, that still gives me real concern, because it looks to me like if you're a credit card company and you have the ability to raise those rates, and it's not probably going to be enough to really give people a lot of concern over the convenience of using that card and so on, but it just looks like we're putting more money into the pockets of the credit card companies at the expense of consumers in Kansas, and that bothers me a lot. But thank you, Mr. Chair.
Representative Gartner.
Well, thank you, Mr. Chairman. I think my question has been answered. I was, trying to go out and buy another refrigerator, but I think I'm going to hold off for a while to see which companies pass this along. But today, Mr. Chairman, isn't it correct today that businesses, retailers started this credit card situation as a convenience to customers? Everybody had credit cards, so they said, we want those customers, so come on in, pay with a credit card. And today, they either take that as an expense, that surcharge, that business, or they add that cost into their cost of services or goods or whatever they're selling. I believe that's probably what they do today. And I guess my concern is just by passing this along, it's just another increase in cost to the consumers. I'd be happy to buy that refrigerator if they probably loaded that $300 into the cost versus showing me a $300 surcharge or a $120 surcharge. I guess I'm a little leery to go down this road, Mr. Chairman. So I don't think I'm going to be supporting this bill.
Representative Bergkamp.
Thank you, Mr. Chair. I guess just get my 2 cents in, and I think just to echo what you said earlier, I think if credit card companies raise their fees to 10%, at some point you incentivize cash. So again, to me, it's more the free markets and giving people transparency where if you're a business owner, some don't have that ability to pass it on today. So I think it's just fair to kind of level the field. And also, if they get too out of whack, I think the market will dictate people will go to cash, or another competitor will step up and say, I'll only charge 2%. And people will go there. Just wanted to chime in. Thank you.
Committee, any further discussion? Representative Baker.
So if everybody was on the same playing field, that theory would be correct. But the large retailers have negotiated rates with those credit card companies that our Kansas retailers cannot negotiate because we're not on the same volume level. It's all about volume. And they get charged a lot less fee because of their massive volume than what the smaller retailers do. It's just another increase in the cost of doing business with a small independent retailer. That's what this does.
Representative Highland.
Thank you, Mr. Chairman. Question. Is there a fee on use of a debit card?
Scott, would you like to respond to that? Or anybody that can definitively answer that?
Is there a fee on the use of a debit card? Yes. Is the Durbin Amendment at the federal level treats debit cards differently than credit cards, though. It preempts that surcharge. We do have the banking commissioner here today in their office if you wanted a more thorough answer to some of those questions. No? They don't want to answer. But the Durbin Amendment does treat debit cards differently than credit cards. So whatever you guys do here today would not impact the debit card environment due to the supremacy clause that the feds have kind of preempted.
Representative Corbett.
Just one more bite at the apple. 46 states already do what we're trying to pass here today. And all this actually does is to give the business people of Kansas the same playing field as the other states. It just seems kind of hard to believe that every time we get in this committee, we try to let business have a break, the doors start to shut down, and then the windows start to shutter. this might actually make someone actually pay cash if they could figure it out. And to me, it's a no harm. I think some businesses may charge it, some may not, but at least take the handcuffs off of them and let them have a chance.
Committee, any further questions? Seeing none in the room and none online, Representative Mason, you may close.
Thank you, Mr. Chairman. I would just say in closing that what this bill would do is provide the option for retailers to do this. Having been a business owner for many, many years myself and having some retail, I can assure you that most retailers are not going to pass this on, but there will be some who will want to do that. The reason they wouldn't pass it on would be because of the competitive factors. And it does provide some transparency. So with that, I'll renew my motion to pass House Bill 2316 favorably.
Committee, you've heard the motion by Representative Mason. All in favor, please signify by saying aye.
Aye.
And opposed?
No.
The ayes appear to have it. The ayes do have it. The motion carries. Committee, I wanted to draw your attention to the agenda for the rest of the week. We will have a slight change on Wednesday. We are scheduled to hear, and I apologize, I was not prepared. I didn't have it up on my computer here. We are scheduled to hear House Bill 2421. That is the House version of the decoupling bill. The way the process works right now, where we've crossed turnaround and we only have a few weeks before first adjournment. We also do have Senate Bill 22, which came over from the Senate. And we will add a short hearing on Senate Bill 22 following the hearing on 2421, just so we can compare the differences between the two, and then if we need to use Senate Bill 22 to work, to insert the contents of another bill to expedite the process, we will have held a hearing on it and be transparent on that, so we can use that for a shell if we need to. But just wanted to make you aware of that. If you have any questions, I'd be happy to attempt to answer them. But I just wanted to make you aware of what the process was, and there will be an agenda change. If you haven't seen that already, that will be coming out for Wednesday this week. If there are no questions, is there any other business that needs to come before the committee? Seeing none, thank you all for your time.